Good day to each and everyone. I am Sandimi and Pamaong of BSHN 3A, and today I'm going to discuss the labor law in Chapter 13. So, for our learning objectives, we must enumerate the classifications of the employees, their benefits, privileges, and policies affecting them. We also need to identify some best practices in handling human resources in tourism establishment and identify the procedures in handling sexual harassment in the workplace. We need also to explain the rights of workers employed establishments in tourism. So for our topic outline, we have here the classifications of employees in tourism establishments. First is regular or permanent employees, probationary employees, contractual or project-based employees, the casual employees, the seasonal employees, the part-time employees. We also have the employee benefits, privileges, and policies affecting them. First is mandatory benefits. So we have here the Social Security System or the SSS, the Government Service Insurance System or the GSIS, the Health and Health Insurance Coverage, Home Development Mutual Fund or the Pag-ibig, overtime pay, holiday pay, and night shift differential. We also have the 13th month pay and bonuses. So for the additional company provided privileges, you also have the employee discounts on services or products, the travel and lodging benefits, the free meals and uniforms, the performance incentives. So for our topic outline, we also have here the workplace policies affecting employees. First is code of conduct and ethics. Second is attendance and leave policies, workplace safety and health regulations, anti-discriminations and harassment policies. We also have here the best practices in handling human resources in tourism establishments. We have here the effective recruitment and selection process, the comprehensive training and development programs, employee engagement and retention strategies, providing competitive compensation and benefit, promoting a safe and inclusive work environment, ensuring compliance with labor laws and industry standards. So the procedure in handling sexual harassment in the workplace. First is defining sexual harassment in the workplace, legal framework and company policies, steps in addressing complaints. We have here the confidential reporting mechanism, conducting investigations, disciplinary actions and sanctions. We have here the preventive measures and awareness program, the rights of workers employed in tourism establishments, right to fair wages and benefits, right to a safe and healthy workplace, right to equal employment opportunities, right to join labor unions and bargaining agreements, right to protect against unlawful dismissal, right to legal remedies and labor dispute resolutions. So for the next slide, it shall guarantee the right of all workers to self-organizations, collective bargainings and negotiations, and peaceful concerted activities, including the right to strike in accordance with law. They shall be entitled to security of tenure, human conditions of work, and a living wage. They shall also participate in policy and decision-making processes affecting their rights and benefits as may be provided by law. So in section 14, the state shall protect working women by providing safe and healthful working conditions, taking into account their maternal functions and such facilities and opportunities that will enhance their welfare and enable them to realize their full potential in service of the nations. So for the section 15, the state shall respect the role of independent people's organizations to enable the people to pursue and protect within the democratic framework their legitimate and collective interests and aspirations through peaceful and lawful means. So for the section 16, the right of the people and their organizations to effectively and reasonably participate at all levels of social, political, and economic decision making shall not be abridged. The state shall, by law, facilitate the establishment of adequate consultations mechanisms. So we have also here the classifications of employees. So employees of a company may be classified as follows. We have here the regular employees, the casual employees, the seasonal employees, project employees, probationary employees, employees for a fixed term, overseas Filipino workers. And we also have here the special workers that includes the apprentices, learners, handicapped workers. So for the regular employees, so these employees who are deemed regular are those who have been engaged to perform activities which are usually necessary or desirable in the usual trade or business of the employer, and those casual employees who have rendered at least 1 year of service, whether such service is continuous or broken, with respect to the activity in which they are employed. We have here an employee who is allowed to work after a probationary period. Workers supplied by a labor only contractor to the principal shall be considered regular employees of the latter. So for the we also have here the casual employees. Casual employees are those whose work is incidental to the business and for a definite period. They do not fall under regular, project, or seasonal employment classifications. However, if they complete at least 1 year of service, whether continuous or not, they attain regular status in their specific activity. So for the seasonal employees who work in industries where services are needed but only during specific seasons. They are temporarily laid off during off season but are re-employed when their services are required again. So their employment is characterized by a periodic work cycles rather than continuous engagements. So project employees are hired for a specific project with a predetermined completion date. Their employment ends upon project completions unless renewed for another assignment. If their work is seasonal, they are employed only for the durations of the season. So we have here also the probationary employees. A probationary employee is one who is on trial by an employer during which the employer determines whether or not he is qualified for permanent employment. Probationary cases of probationary employment. The employer shall make known to the employee the standards are made known to the employee at the time. He shall be deemed a regular employee. It is settled that a probationary employee enjoys only a temporary employment status, not a permanent status. In general terms, he is terminable anytime as long as such termination is made before the expiration of the 6 month probationary period. So the next slide is the employees for a fixed term. These are employees covered in employment contracts providing for term employment or period employment. Stipulations providing for a fixed period employment are valid when the period agreed upon has been knowingly and voluntarily agreed by the parties without force, duress, or improper pressure exerted on the employee, and when such stipulations were not designed to circumvent the laws on security of tenure. So for the overseas Filipino workers, also known as a migrant worker, overseas Filipino worker refers to a person who is to be engaged or has been engaged or remunerated activity in a state or which he or she is not a legal resident. A person to be engaged in an applicant worker who has been promised or assured employment overseas and acting on such promise or assurance sustains damages or injury. The laws which governs overseas employment is Republic Act 8042 or the Migrant Workers and Overseas Filipino Act of 1995. So for the next slide is special workers. Here are the apprentices. Apprentices are workers undergoing training under written apprenticeship agreement. They are trained for an approved apprenticeable occupations for a specified period. The employer commits to training the apprentice, who in turn agrees to the terms of the training. We also have the learners. Learners are trainees hired for semi-skilled and industrial occupations that are not covered by apprenticeship programs. They acquire practical on-the-job training for a maximum of 3 months. Employers may hire learners with no experience. Workers are available. We also have here the handicapped workers. Handicapped workers have impaired earning capacity due to age, physical or mental disability, or injury. They are recognized under the Magna Carta for the disabled persons in RA 7277. These laws ensures their rights, equal opportunities, and protections in employment. So also have here the benefits, privileges affecting employees, and policies. So for the minimum wage, by virtue of the Republic Act number 6727, Wage Rationalization Act, the determinations of minimum wage rates are now within the functions of the regional tripartite and productivity board. The concept of minimum wage means more than setting a floor wage to upgrade existing wages. Minimum wages underlies the effort of the state to promote productivity, improvement, and gain sharing measures to ensure a decent standard of living for the workers and their families, to affirm labor as a primary social economic force. So for the next slide is collective bargaining. So this means conferring promptly and in good faith for negotiating agreements with respect to wages, hours of works, etc., and entering into written contracts called collective bargaining agreements, or the CBA. Adjustments of grievances, etc. So the provisions commonly found in the collective bargaining agreements are: first, the enumerations of management rights or reservations of the union, recognitions and security, wage and fringe benefits and their administrations, physical working conditions, selected personnel management and plant operations practices, the grievance and arbitrations, the durations of the contract. So for the next slide is a labor management council. So under Article 255 of the Labor Code, it reserves the rights of the individual employee or a group of employers or the unionized or non-unionized to present grievances to their employer at any time, with or without collective bargaining, with or without exclusive bargaining representative. The Department of Labor and Employment promotes the formations of labor management councils, or the LMC, in organized or unorganized establishments. An LMC, either as collect council or committee, can serve as a forum where management and employees may air their concerns, shorts, and collective bargaining. It is largely a communications mechanism, which includes, so it means it is a largely a communications mechanism which includes preparations and or resolutions of disputes. So for the next slide is the sexual harassment in the workplace. So under Republic Act number 7877, also known as the Sexual Harassment Act of 1995, the sexual harassment is committed by an employer, employee, manager, supervisor, agent of the employee, manager, other persons who, having requests or otherwise requires any sexual favor from others, regardless or whether the demand, request for requirement for submission is accepted or not. We also have here the drug testing under RA 9165. Employees may be subjected to random drug testing in accredited laboratories to ensure workplace safety. So, employers must establish policies or drug testing as part of their company regulations. A positive test result may lead to administrative sanctions, including suspension or terminations. Next is the retirement. As per RA 7641, employees age 60 to 65 who have been served at least 5 years in company are entitled to retirement benefits. In the absence of the retirement plan, the law mandates a minimum retirement pay of half a month's salary per year of service. The compulsory retirement age is set at 65. We have here the uniform policies. Employees in tourism establishments must adhere to uniform and grooming standards required for the DOT accreditations. Proper attire and cleanliness contribute to professional and welcoming environment for guests. Compliance with these policies is necessary for maintaining service quality in tourism-related businesses. So the SSS PhilHealth ECC Pag-ibig. So these government programs provide financial security and assistance, provide sector employees. So SSS offers social security benefits, well-paid covered medical expenses, and hospitalization. ECC provide compensation for work-related injuries and pag-ibig assist with housing and savings program. So maternity and paternity leaves. So maternity leaves benefit are provided under Republic Act number 8282, also known as the Social Security Act of 1997. Female employees who have been paid at least 3 monthly contributions within a 12 months before childbirth or miscarriage are entitled to 100% of their average daily salary credited for 60 days or 78 days for the cesarean delivery. Employers must advance full payment within 30 days, and the Social Security system reimburses the employer upon verifications of the payment. So the paternity leave is benefits are granted under Republic Act number 8187, also known as the Paternity Leave Act of 1996. Married male employees in both private and public sectors are entitled to 7 days of paid leave for the first four deliveries of their legitimate spouse with whom they are cohabiting. This leave allows fathers to support their wives and newborns during the crucial postpartum period. So the rule of service charges applies only to establishments collecting service charges such as hotels, restaurants, lodging houses, nightclubs, cocktail lounge, massage clinic, bars, casinos, gambling houses, and similar enterprises, including those entities operating primarily as private subsidiaries of the government. All services charges collected by the hotel, restaurants, and similar establishments shall be distributed at the rate of 85%. For all coverage of 15% management, the share of employees shall be equally distributed among them. The 50% shall be the disposition of the management to answer for losses and breakage and distributions of managerial employees to the discretions of the management of the latter case. So the employment contract. An employment contract is that by virtue of which one person binds himself with respect to another employer to place at the service of the latter his own efforts in work, and the latter in turn agrees to pay him a compensation proportional to the time or to the concept of the employment contract is regulated under the provisions of the Labor Code of the Philippines, the Civil Code of the Philippines, and the other special laws. Execution of parties are free to stipulate terms and provisions in the contract as long as these terms or employment contract is impressed with public interest. Hence, other are so, legally speaking, a contract of employment is consensual in nature which does not require additional formalities for its validity. So, a legitimate labor organization or the LLO has the authority to represent its member in legal claims related to employees. For collective bargaining, a labor union must be certified as an exclusive bargaining agent through certification selections. So a strike is a temporary work stoppage by employees due to the labor dispute, while a lockout is one of the employees' temporary refusal to provide work for the same reason. Labor disputes cover issues related to employment terms, conditions, and representation, even if the parties are not. I think that's all for my report. Thank you, and God bless us all.